Welcome back to the channel, everybody. Thank you so much for joining me and allowing me to continue to be your daily advocate. If you're new here or you're not subscribed for any reason, please do me a huge favor and hit the subscribe button. Thank you to all of you who have been watching and following me for so long. It truly means a lot, and I'm glad that I can be this person.
Attorney John Deaton's most recent comments on the SEC versus Ripple case highlight two pieces of critical evidence. And these specific pieces of evidence show that the SEC absolutely cannot prove its case. It is not correct. And so this is all just shared within the last couple of hours or so, and I thought it was, well, per usual, on point. But man, it's just another one of these threads from Deaton. It just really cuts to the core of what's going on here and highlights the degree to which it don't make no darn sense that the SEC is being a bunch of little baby back biatches going after Ripple, claiming that XRP is actually an unregistered security of Ripple. Complete and utter nonsense. So I think you're really going to enjoy this one, but I do want to be clear at the outset. I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who makes YouTube videos about crypto stories, but just as a hobby and just for fun. Now, John Deaton highlighted this article, which I'm not going to run through other than maybe like a couple sentences, but this is written by Rosalind Layton, senior contributor at Forbes. This was written March 11th of last year, 2021, and it's titled SEC Stumbles in Ripple Case, Lost in a Maze of Its Own Making. And so I covered this article in its entirety back when she first published this almost an entire year ago, and it's a fantastic piece. But John highlighted a sentence from this. So check this out. John writes, last year, Rosalind Layton brilliantly wrote the following. Here's the quote that he shared from Rosalind Layton's article. Put two and two together, and the SEC is saying that Ripple and its two top executives had to have reasonable knowledge of something 7 years ago that the agency itself wasn't sure about last Friday. Exactly. So Brad Garlinghouse and Chris Larson and all the executives at Ripple, they were supposed to know from the get-go that what they were doing with XRP was illegal, even though the agency itself didn't know, which highlights the degree to which this is absurd. And I also like this. There's one or two sentences here I wanted to share with you. And mind you, this was before Gary Gensler had actually taken over as the new dictator at the SEC, so he wasn't Kim Jong-Gary yet. He was just Gary Gensler back then. But anyway, check this out. This is from Rosalind Layton. By watching the volley of filings heat up the case docket, it has become clear that the SEC's decision to sue Ripple was misguided. And in recent days, a series of developments are starting to make it look like a disastrous mistake that the presumed incoming chairman, Gary Gensler, will have to sort out. Folks, I gotta ask you, drop a comment below. Do you think that the SEC regrets going after Ripple yet? Because they're in such a piss-poor position, they've got to be concerned. And the way that's going to manifest itself ultimately is in settlement. That would be my guess. Now, I think there's going to be less opportunity for a settlement if, it's an if, the fair notice defense, if Ripple isn't allowed to argue that, might diminish the odds of settlement to some degree anyway. Not saying it wouldn't happen necessarily. But still, if you're the SEC, are you not yet worried? Because I'm telling you what, if I had to argue for one side or the other, I would hate my life every single day if I had to argue. If I were an attorney for the SEC and had to argue the nonsense that they're arguing, I would hate my existence. Anyway, John continues. We all recently learned just how poetically accurate Dr. Layton was when she wrote that sentence last year. Two pieces of critical evidence demonstrate her accuracy. Number one, the October 2012 Perkins-Coie memo. And so, folks, I'm assuming that you're all caught up at this point because it's been such huge news. But what's being referenced there, just in case you're not aware, is it's a document from the law firm Perkins-Coie sent to Chris Larson and Jed McHale. I can't remember if anybody else was copied on it at the time, but back October 2012. So Ripple had existed for all of like a month or a few weeks at that point. Brand new company. And so they want to find out that, okay, how can we proceed utilizing XRP? You know, a cryptocurrency which wasn't even out in the open market at this point. Like, how can we proceed? And they ended up getting word from their their legal team, Perkins Coie, that the way you want to go to market, you've fleshed out the ideas. XRP would not be likely at all to be viewed as a security by the SEC, but it's not that there wasn't any risk. It's just that when it comes to anything in life, you're never in a situation where there's literally zero risk. But no, it was made very clear. It did not look like XRP, the way that it was to be utilized by XRP, did not look at all, really, that like it would be viewed as an unregistered security of Ripple. So that's one thing, the October 2012 Perkins Coie memo. That's one of the two pieces of evidence. And the second one is the SEC's June 13th, 2018 legal analysis of XRP. And folks, that's a big one, and John fleshes out why. Check this out. The Perkins Coie opinion memo concluded XRP was not a security. Although we do not know exactly what the XRP memo says, we know what it doesn't say. Judge Knepper ruled the SEC's analysis of whether XRP is a security is privileged, so the public and Ripple do not get to read it. But we don't need to know what it says, because what it doesn't say says everything. Judge Knepper stated that the memo does not make a recommendation. What that means is that the SEC enforcement lawyers conducted an in-depth analysis of whether XRP was a security, but didn't recommend an enforcement action. It is so obvious that in June 2018, the SEC enforcement lawyers did not definitively conclude that XRP was a security. So folks, think about this. This is monstrous, and so even though Ripple doesn't get their hands on it, well, again, the judge saw it first of all, but additionally, what does this mean? In terms of whether or not Ripple should have known that what they were doing was wrong, the answer becomes stunningly, amazingly obvious. Could not be more crystal clear, because even the SEC didn't know. In 2018, they still didn't know. John continues. If it was clear and obvious that Ripple violated securities laws, there's no doubt. Oops, I just scrolled too fast. Lost it. Here it is. Okay. If it was clear and obvious that Ripple violated securities laws, there's no doubt there would have been a recommendation to enforce those securities laws. There wasn't. It doesn't matter what the memo says. If it found XRP met 3 out of 4 Howey factors, so what? You need all 4. As Dr. Layton stated, over a year ago, how could Chris Larsen be reckless in not knowing XRP was a security in 2013 when SEC enforcement lawyers couldn't make the case in 2018? The fact that Larsen and Brad Garlinghouse have an opinion from the same law firm that helped Hinman write his speech, and it concludes XRP is not a security 6 years before that speech, demonstrates the SEC can't prove Brad and Chris actually believed XRP was or is a security. The fact that SEC enforcement lawyers couldn't conclude XRP was a security in 2018 destroys the SEC's ability to prove Larsen and Garlinghouse were reckless. To prove recklessness, it must show it was obvious to anyone under those circumstances that XRP was a security. If it wasn't obvious to the experts themselves, the SEC, then it can't be so obvious to be reckless. My next thread will prove how the case against Garlinghouse and Larsen was dead upon filing. I might also discuss why Brad and Chris might owe a thank you to Jay Clayton. So I'll be sharing that in the future, no doubt. But that'll be for another video. Now, I do want to share this also. There's a very short thread here from an XRP community member who is an attorney, and his name is Bill. And he wrote the following on this exact topic, having to do with the Perkins Coie legal memo from October 2012. And he wrote the following. Check this out. The October 2012 Perkins Coie legal memo to Chris Larsen states, quote, "We understand that the primary reason for purchasing XRP is to facilitate online commerce, not to engage in speculative investment trading. Given the commercial nature here, XRP should not be considered securities," end quote. The SEC knows this is important, which is why they allege in this lawsuit that XRP has no utility. They wish to argue it is only acquired for speculative investment. Perkins Coie's analysis focused on the common enterprise prong of the Howey test, whereas the SEC's 2019 document Statement on Framework for Investment Contract Analysis focuses on the reasonable expectation of profits from efforts of other prongs of Howey. In respect of the common enterprise element, the SEC states that a common enterprise typically exists with digital assets. So this may be the big issue on applying the Howey test, but it may not be so clear the common enterprise prong will be satisfied by the SEC. The Perkins-Coie legal memo analyzed the common enterprise prong by reference to the concept of horizontal commonality, meaning the tying of each individual investor's fortunes to the fortunes of the other investors by the pooling of assets, usually combined by the pro-rata distribution of profits. While noting the Ripple network was more likely to be a common enterprise than Bitcoin, they concluded it appeared that the business model of Ripple seeks to disperse rather than pool XRP users' funds throughout the open source Ripple network. It is interesting that the SEC's framework document glosses over the common enterprise prong and cites no case to support why. Why it finds that a common enterprise typically exists for digital assets. The SEC has a lot of difficult challenges with this prong and the reasonable expectation of profits from the efforts of other prongs of the Howey test. And so think about it. Why is it that they're not focusing on the common enterprise prong? Why is that? Might it be because, well, first of all, there isn't a common enterprise, but even if you tried to make an argument, it would be so pathetically weak that it just wouldn't work anyway, not even in court? Because think about this, if there's a common enterprise, and this is where there's a hard break on whether or not XRP is a security, and it's always been the case. If Ripple, the company, goes away, XRP continues to exist and developers continue to build on top of the ledger. So if Ripple's a common enterprise, how the hell can that be true? It could not be more obvious, which is one of the million reasons why this entire case is so freaking offensive, the fact that it is even occurring. It's completely absurd. There is no common enterprise. If a cryptocurrency, if it is sufficiently decentralized to the point where the company here, in question, Ripple, if they don't have any special permissions over the blockchain, well, how the hell could there be a common enterprise? And again, if there's not a common enterprise, that's one of the 4 prongs of the Howey test, then it doesn't pass the Howey test, meaning it's not a security. Because it is the case that in order for something to be a security, it must pass all 4 prongs of the Howey test. Not 1, not 2, not 3, but all 4. There is no common enterprise. It could not be more clear. This whole thing is disastrous and just offensive. The fact that this lawsuit against Ripple even exists and it's just harming innocent XRP holders out there, it really grinds my gears, folks. So anyway, I thought Bill did a good job of explaining his perspective on that topic, and it tied directly to what John Deaton was talking about because it goes back to what was written in the October 2012 Perkins-Coie legal memo.
So enjoy your day, everybody. I'm always here for you. Leave any comments or questions below, and be sure to subscribe. But thanks, everybody. I really appreciate you. Enjoy your day, and I always have your back. So thanks so much, everybody.